Well, good reading. Good evening, everybody. My name is Brian Burke. I'm an attorney with Shehab Burke, based here out of the Dublin, Ohio, part of the Columbus, Ohio area. It is Monday. It is 6 p.m. And it is time for our firm to be here talking about, just interesting immigration issues that we want to bring up. I would note that conspicuously absent is my friend and partner, Sam Shehab. Sam is doing some traveling. He might be watching us right now. If he is, fantastic. But what we're going to do is we're going to do what we always do here. We're going to talk about some immigration stuff that we want to bring up, of course. And we are going to, of course, on the back half of this presentation, take some questions from you. As always, so start getting those questions in now because the back half of this presentation is really going to be about us sort of, and by us, I mean me, excuse me, sort of thinking about those things and sort of giving you some insight as to how the law might work on those matters. But without further ado, let me get to the substantive topic for today, which is one that clearly I want to bring up because I'm the guy talking. So when Sam and I are here, we are usually talking about, well, most of the time we're talking about the struggles of having a pending employment-based green card, which is a really important topic because there are so many people out there waiting for with a pending I-485, waiting to get those green cards in hand. A really great topic. And lately, there's been sort of a focus because we're in the H-1B cab season upon H-1B cab stuff. And I always try to like to hit upon issues and topics that maybe people aren't thinking about as much at the moment. So that's how we get to our topic for tonight. Tips for the long-term H-1B user. Somebody who hasn't been able to get to the, pending I-485 yet. They're sort of sitting out there with perhaps with an approved I-140, waiting for their date to come up. So that's the theme I'm hitting on today. That's what I'm going to talk about. I think I have some pretty good things to talk about. And again, after that, we'll dive into your questions. So get those questions coming in because that's what I'm here for. So, number one, sort of question we get from the long-term H-1B user is, when can I file my H-1B or when should I file my H-1B? And right now, for example, somebody might be planning to go for stamping at the consulate, and they'll ask, should I file a new H-1B? That's something where I'd say, hey, it never hurts to come to the consulate with a fresh H-1B petition. Why? Because the folks at the consulate will look at your H-1B petition and they're going to want to talk to you to confirm that the details of the petition are reflective of the reality that you're working in. And even though I'll give you a common scenario where this can be a challenge. Let's say you are, per your H-1B petition, working from home, right? And you are providing services per the terms of your H-1B petition to end client A, right? And then suddenly your project changes to end client B. Whereas policy pretty clearly, in most circumstances, would not require you to file a new H-1B petition. It might, the consulate may not agree with that. And if they're looking at your H-1B petition saying, wait, this guy's telling us he's working for client A, but his H-1B petition says client B, it's a sort of thing that can cause problems, cause delays at the consulate. Bottom line there's usually an excuse for you to file an H-1B amendment really at any time. USCIS, they're sort of very fuzzy as to when they will take an H-1B amendment. And USCIS, in our experience, doesn't reject, taking money, taking filing fees for a case if you have a plausible reason for filing it. So if it's in your best interest to file an H-1B, I'm using the example of amendment, do it. If you're going to the consulate, it does not hurt you to have a fresh one. You may not need one. Talk to your immigration counsel about that, but it's just something that comes to mind. Traveling, if you're a long-time H-1B user, you're going to need stamping. Have a fresh H-1B. It's a good idea. The Department of State does really look into your H-1Bs. So speaking of the subject of, filing those H-1Bs, let's talk about filing H-1B extensions. And, when is a good time to file an H-1B extension? Now. Bottom line is I won't get into politics. I won't have a political debate with myself. But we are looking at a potential change in the executive branch. There's an election coming up in November, and we don't know how that's going to go. Uh, Somebody who's relying upon H-1B, get that extension in. Really, you want to have that sort of in and approved if there's going to be a change in the executive branch before they take power in January of next year. Why? Because frankly, during the last administration, we saw negative immigration results. Pretty much as soon as they got their hands on the reins of power over the government, over USCIS. And honestly, it is my estimation that they will have their hands on the wheels of power within USCIS quicker than they did last time. Because honestly, the sort of dialogue, the story is they weren't expecting to win an election. They weren't really prepared to take over. This time, I expect them to be prepared. So, last administration, H-1B approval rates plummeted. We talked about this a couple of weeks ago, live here. Right now, it's a really, really nice climate to get your H-1B extensions in. Well, great. Do it now. Couple other reasons, one other great reason to get your H-1B extension in right now is an H-4 extension is also sort of relevant here. So about 2 years ago, in January 2023, there is a settlement agreement between USCIS and people who sued them in a case called Edikuni. I think it's Edikuni v. Mayorkas is the name of the case. But the bottom line is that USCIS sort of released an agreement, or entered into an agreement, where they said, we're going to approve H-4s and EADs at the same time as H-1Bs. Essentially, this lawsuit was about people complaining about massive delays in H-4s and EAD processing. So they've said, if you file your H-4 and your EAD in the same envelope as the H-1B, all three of them together, they're going to approve those H-4s at the same time. That settlement, that agreement they entered into, is going to end in January 2025. So bottom line is, I would want to get my H-1B along with my spouse's H-4 and EAD in before that time to get the benefit of quickly processed H-4s and EADs at the same time as the H-1B. And combining that with the potential change in administration happening around that time, I think you'd really want to try to get your immigration status squared away for the next couple of years before before a potential change of executive administration comes in. And sort of on a related note, I would say, why get it in? Why get that 3-year approval? Because it's when you file an H-1B case, for example, it is relatively easy for USCIS to deny it. You get your case, they'll maybe issue an RFE. They don't approve the case after that RFE. You're done. They've given you nothing. Once the case is approved, it's a lot more work for them to take away your H-1B status. They have to issue a notice of intent to revoke. So bottom line there is, get your H-1B in sooner rather than later, especially before the end of the year, get an approval, because there are so many moving parts out there that it's always in your best interest to, it's basically taking care of the risk. Get your approval in, get your status secured before the risks really kind of take effect. So, H-1B, big picture, H-1B extensions, do them now, do them when you need them. Great, fantastic. So, on a sort of long-term H-1B note, I'll talk about travel. And, travel, people always ask me, they say, Brian, is it safe to travel? And I always give them the old immigration lawyer's response. They're never going to stop you from leaving the United States. It's getting back in, getting a visa and getting back. That's the real difficult question. And I understand there are a lot of people who won't travel because they are very much worried about their ability to come back. But find the time to travel. I'll tell you why in this attorney's head you should. INA 245K. I've been occasionally sitting at green card interviews out there with somebody. I'll be sitting in the waiting room with them, and they'll be sitting next to me, and they'll say to me, Brian, I'm a shoo-in. I haven't left the United States, since I got here. How can they deny me? I am already here, already long here. What's the problem? The problem is that, the rules for applying for an employment-based green card when you eventually get to that step are that you must have been maintaining status up until the time that from the time you enter the United States up until the time that you filed that green card. And essentially, if you haven't left the United States in a decade, you are giving them a lot of things to look into. All they have to do is find some sort of oops in your status in the last decade, and they've got you. Meanwhile, the person who, stayed here for 9 years and then traveled, applied for a visa, and, came back and then applied for a green card a year later, they only have 1 year of immigration baggage, immigration potential problems in their past for the government to look into. I guess so. That's sort of it. Plus, travel's good for you. Go see your family. The immigration attorney in me, always has to warn people that the risk is, of traveling is that you might not be able to come back. But bottom line is that something I always have to say is, live your life. If you let immigration, your fears control everything, well, you're going to be a miserable person. So, big picture, travel now. It's first of all, you're going to get the benefit of seeing your loved ones, your friends and family abroad to the extent that they're there. Secondly, it can only kind of help you in sort of cleaning up your immigration history. If you're intending to apply for a green card in the future, it sort of puts things outside the realm of government inquiry. However, just got to warn everybody that if you have you think you have immigration issues in your past, and you're planning to travel, you really got to be careful with that and talk to an attorney about it, because if you have issues and you say complete a DS-160 and for visa stamping and you aren't truthful about them, you can create problems for yourself. Mainly that, if you've been untruthful with the government, you have engaged in fraud and misrepresentation, and that can be a problem, really, as well. Obviously, if they're adjudicating a green card application, the fact that you sort of fixed an issue with INA 245K would not be fixed if you lied to get back to the United States. So, a lot to think about there, and well, there you go. Again, I'm just sort of going down my favorite long-term H-1B holders, and I'm going to sort of holder issues, and I'm going to really kind of get to sort of one of my favorite ones, EB1, uh, or really kind of any other category. Especially for people from India and to a lesser extent China, they look at the backlog and they ask me, Brian, is there anything I can do to get me there faster? And there's sort of wacky scenarios that sometimes people sort of fix that problem with. If you're single, you get married to a U.S. citizen. That happens. It's a great place to end up being married to a U.S. citizen. You're in the United States. Sure, gets you an immediate green card. EB5, if you find yourself, a millionaire, you can get a green card through the EB5 program. It's not exactly quick visa availability, but it's, a lot better than EB2 or EB3 in terms of wait times. But really, for most people, the sort of most practical goal is to sort of shoot for EB1. And, I guess EB1 is not practical for everybody, but, I bring it up because it is something you can achieve. EB1C, if you are working for the right kind of company, you are at the right kind of level, it is possible for you to work with your employer and to structure your life such that you spend some time outside of the United States working as a manager. They bring you back to the United States as a manager, L1 visa. You apply for EB1C, you get a green card. You're able to take advantage of your EB2 or EB3 priority date, and you get a green card quicker that way. Ask me how I know. We've done it for people. It is a viable path to a green card, but the challenges there are having the right employer. Obviously there's lots of, if you have a strong relationship with your employer in the United States and they don't have international operations, not viable. But I find that it's sort of most potentially viable in sort of small companies and big companies. Big companies, are going to have huge international presences, and you can simply put in for a transfer another position outside the United States. You're golden. And with small companies, smaller companies, the cool one is, if you have a good relationship with the leadership of the company, them, you can leverage those relationships. Yeah, I'd love to lead a team, in country X for a year for you, as long as you're willing to bring me back, after that, and get my green card that way. It's the sort of thing you can achieve. When it comes to EB1A, really, I talk to a lot of people about this. One of the things we do around here is we'll usually offer, free consultations on the subject of EB1A qualifications. And, you know, um, not everybody can get there. And part of my job as an attorney is to try to give people, honest opinions. But, when I think about EB1A, my sort of running joke, my saying around the office is the three Ps: patents, papers, and PhDs. If you're finding, patents, patents registered with the government, papers, professional scientific papers, and PhDs, which are usually associated with professional scientific papers, it might be a conversation worth having. Um, and that's sort of, my take on it. I tend to focus in on papers and PhDs a lot because, as people who've talked to me about EB1A know, that I sort of believe that the whole category is sort of tailored for people who are in the academic fields. But just remember, just because you are not, wearing a lab coat every day doesn't mean EB1A is off the table. You know, um, Outstanding ability in business, in science, business is also on the list. So just because you aren't working in an academic field doesn't mean EB1A is off the table. It's just you sort of have to be an absolute superstar to get there. And again, executive summary, it's not for everybody. But bottom line, long-term H-1B, keep the option of EB1A on the table. You are in the United States. We are, I don't mean to toot the collective horn of the country, but we are on the cutting edge of everything. And odds are, if that's where leaders in whatever field you are going to be. And get involved in your occupation, and opportunities can arise to sort of get you to there. So, long-term H-1B holders have to bring up, changes of employer. I hope, for the sake of people in our audience, that the situation is otherwise. But fundamentally, it's looking like the priority dates, the visa bulletin, is going to slow down to sort of pre-COVID times, moving weeks at a time rather than months. It just does not look like. The reason why is I don't expect we're getting negative, negative, feedback in terms of, are they going to change the laws on visa availability? We're definitely seeing the consulates abroad at full sort of power when it comes to their ability to issue family visas, meaning I'm not seeing a source for people being able to get visas any faster in the traditional EB2 or EB3 categories. So I guess I bring this up because, if your prior date's 2012, 2013, even, into 2014, I think there's some reason to hold out hope that, your number will come up sooner rather than later. But I get sort of depressed when I think about, 2016, 2017, 2018 priority dates, which are already quite old, but are just seeming so far off the way the visa bulletin is. I guess I bring all this up because people for the last couple of years, they're very much worried about, what happens if my priority date comes up, I need to file a green card, and I'm no longer with the employer that sponsored me. The bottom line, if with a priority date like that, the later ones, you are kind of in it for the long haul right now, and you do have flexibility to change employers. You get to take as long as your I-140 is approved for their prior employer, you get to take your priority date. As long as it's approved for more than 6 months, you get to keep it approved and use it to extend your H-1B, meaning really kind of the world is your oyster. Change jobs, take advantage of opportunities. They are out there. And we'll just go for it. The bottom line is the perm processing times aren't coming down, but I don't think the visa bulletin wait times are getting shorter. So take advantage of new opportunities because because you should. It's good for your life. I'm going to try wrapping up, my sort of, my sort of thoughts for the long-term H-1B user, and I am going to certainly get to the Q&A section of this, so keep your questions coming in. But I'm going to also advocate, for taking advantage of some of the lesser used H-1B rules, um, especially in this time of layoffs. Here's a good one. Just remember, this is something that a lot of people know. A part-time job can be perfectly fine for a full-time H-1B visa that keeps you legal in the United States. In this time of layoffs, there are people out there scrambling to find any company that is willing to, sponsor them. Um, it is a fairly regular thing that somebody needs a project for, on the part time. As long as certain requirements can be met, a part time job can allow you to legally stay in the United States on an H-1B visa. Essentially, you have to be paid enough to sort of live on, but if you're on a pinch, that can be a way to sort of save your immigration status in the United States. Perfectly legitimate, perfectly normal. They don't come up that much. I kind of wish people would because they're neat and interesting cases. But part time employment, full time H-1B visa. Sort of on a same or similar note, second employment. Very popular trend right now is with people with pending green cards to leave behind their H-1B status, use that green card EAD to go ahead and get take multiple positions. Just as a reminder, you can do that on H-1B visa, provided that somebody is sponsoring you for on a second H-1B petition. Obviously, I've had this conversation, literally 100 times with people, and they will tell me, Brian, the opportunities just aren't as great out there for when H-1B visa sponsorship is required. And that I understand. There are certain employers out there that won't touch H-1B visa sponsorship with a 10-foot pole, and such is life. But if you find yourself in an opportunity where you might have the means to do, some additional work, second employment through a second H-1B petition through a second employer is a viable option out there, and that's that. And there you go. And I guess I'm going to pick one that makes a great segue to me taking questions from the good people in our audience, and sort of something that my favorite part of being an immigration attorney is sort of implemented here. Remember, you can have your own private counsel for your immigration status when you're on an H-1B visa. So let me expand upon this. So the rules are that you cannot pay the attorney's fees or the filing fees for your H-1B visa. Great, fine. Those are always the rules. But when you have an issue related to your H-1B visa relating to your status, you are allowed to hire your own private counsel to ask some questions. And for me, that is sometimes some of the most rewarding work that I can do as an immigration attorney. The common scenario is, somebody will call me up and say, hey, Brian, I'm reaching out to you because, I work for some other company I've never heard of, and I'm having this problem with my H-1B status. My company's not paying me. My company isn't doing XYZ. And what can I do? What are my options? It's a great conversation to have with an immigration attorney, and just, well, keep the keep the doors open. Keep that idea open, because again, there are so many things related to your personal immigration status that you are that where you can actively take the advice of your own personal counsel, and to sort of maybe get perspective. And that's my favorite part of it is people leave a conversation with me. They say, Brian, thank you. I understand better, and of what my options are and what the future looks like, that sort of thing. So if you have those immigration questions, that are really kind of personal to you, you can always hire your own immigration counsel to sort of pick their brain and give you an outlook on it. Always, of course, try to find somebody who does employment immigration if your really questions are immigration related, because maybe like 10 to 15% of immigration lawyers really do employment immigration, and the rest, well, don't. So those are the things I sort of wanted to hit on. The sort of topics about long-term H-1B, a really sort of H-1B focus session, because, hey, that's what I wanted to talk about this week. So now is as good a time as any to sort of make a segue to the section of our show. And I keep on saying our because I'm used to having Sam here, where we talk about your questions. The questions you put in the chat, maybe a couple questions that I've gotten, outside of this before the via email before this, or via other means. Happy to answer them. Keep them coming in because it gives me something to think about and gives me stuff to talk about, especially a great challenge when my friend Sam's not here. But just keep in mind that when it comes to this session, you obviously, clearly, an attorney-client relationship is not created by this. I'm only getting just a little bit of information about you, and I'm sort of robbed of the ability to answer, follow-up questions. Excuse me, ask follow-up questions and really kind of pick your brain. And that's why I'd encourage anybody who really needs help on an immigration matter to, you know, uh, pick immigration counsel of your choosing. There's so many great immigration lawyers out there who would love to help you out. And ask them. A lot of attorneys will do a free consultation, and even if they don't, well, that's perfectly fine as well. The advice you get will more than likely than not be really worth what you spend on it. So, without further ado, I'm going to check out the questions that you guys have for me here. And let's make sure there we go, works well. It's my name bar goes out of the way. So from somebody with a great YouTube handle, immigration, I want that handle. Hi Sam and Brian, I have two green card cases, family based and employment based. Family visa number availability is immediate and filed in August 2023, and employment based priority date August 2013. I was called to an interview on employment and it was canceled due to some protest in the region saying it will be rescheduled. Oh, I'm sorry. It hasn't been rescheduled. An inquiry yielded nothing since employment priority date is not current. Is there anything I can do to get this going on my family petition, like file an inquiry or contact the senator? So, immigration, that's a pretty good question. And, I will sort of wear both my hats as the employment and family immigration options here. And I guess I will speak for a minute about maximizing your H1, maximizing your options here. So you have two great cases going on and great, fantastic, both viable paths to a green card. You shouldn't let one of them go until your case is until your green card's approved. Until a green card's in your hand, you should keep those things going because you just can't count your metaphorical chickens before they hatch. But the fundamental question is, I have a family case going. How can I get it approved? So let's talk about a typical family-based immigration case. Typically, a marriage-based immigration case will often, come to an end with an interview at the local USCIS office. Fine, you kind of got robbed of that. I guess. Is there a great way to get this going? I guess my first level of inquiry immigration is that you might be a bit premature to get the government to take notice and think your case is moving too long. Why? Because you have if you filed a separate I-485 based upon your family petition, your I-130 petition, that has only been in process since August 2023, less than a year right now. I don't know which city you're in, but if you go to the USCIS case processing time website, you will find that most processing times for family-based adjustment of status processes are greater than a year. Meaning they may not be taking an interest, such as in a service inquiry or even an inquiry through the senator. In fact, they probably wouldn't even take a service inquiry on the case, the USCIS website. But contacting the senator, it's not crazy to do. There's that saying that a squeaky wheel gets the grease. I would say that the realistic, most likely response that you would get from contacting a senator's office would be them saying, hey, your case is, they're saying your case is within normal processing times. We can't answer you. But if you put in that inquiry, the bottom line is your I-485 has been pending for more than, you've had another I-485 that's been pending much longer. I didn't really see what the employment-based, employment-based priority date of August 2013. Odds are you've had an adjustment of status case pending since October 2020. One thing that might be able to sort of, make for a compelling argument to get your family base, get you a green card sooner rather than later is the fact that, essentially it's sort of a transfer of underlying basis sort of scenario, saying, "Hey, dear USCIS, I have a green card, pending case uh, I have a pending, I-45 case that dates back to October 2020. I have now a new family-based I-130 petition. Approve that case." Essentially, that's a scenario where you could arguably put in a request for a transfer of underlying basis, and maybe you might be able to argue that your case should be approved now because long pending adjustment of status plus current visa equals green card approval. But you'd want to think pretty carefully about that by virtue of the fact that there are limitations on how many times they will allow you to do a transfer underlying basis. So I'm going to sincerely hope you have worked with an immigration attorney on both of these, and I think there is um, there is some sort of risk reward analysis to have about, do you start pushing them on the fact that you have a long pending I-45 with with an immigrant petition approved in another category. In logic, by any logic, immigration, clearly they should approve your case. If they've been doing all the right work on your I-45 for years, there's no reason why they shouldn't approve it now, um, by just putting the new I-130 plus the I-45 together. But it's something where, of course, you got to really think carefully about that before doing it. A good question, though. I guess it sort of reminds me of something I brought up during the first half of this presentation. It's sort of maximizing your options. Actually, something I didn't get to bring up, but when it comes to people on long-term H-1B visas, to tie it back to the sort of first half of this presentation, something that sort of I always encourage people to do is maximize your options. For example, if there's somebody on an H-1B visa and a spouse on an H-4 with an EAD, for example, I would encourage, that's the spouse who's on dependent status to try to find paths to a green card. I meet a lot of people with, pretty impressive spouses who never go for an I-140, and I always like a backup plan. So you have a great backup plan, immigration. The fact that you have a family-based I-130 that will likely sooner rather than later get you a green card. And I would definitely encourage talking about, options to sort of push them and prod them and moving it forward. And I guess I would say everybody should try to have their backup options. So if you have a spouse that, is a fancy professional person too, and they're just sort of relying on an H-4, they could definitely, if they can find an employer willing to sponsor them for an H-1B visa, just to get on it for a little while, to have that option. Because what I worry about for people is somebody on a long-term H-1B visa in sort of interesting economic times such as this, they get laid off, and then suddenly, well, if their spouse can't get onto H-1B status, they're both going to be forced to leave the country. It's not a pleasant conversation to have. So I would encourage everybody to just sort of take advantage of as many immigration possible grounds as they can possibly conceive of. And I sort of applaud you, immigration, for taking what is obviously a pretty obvious one, but still. So I'm going to move on here to Lester Valera. Lester says, "Hello. So we're currently waiting for our priority date for EB3 visa skilled worker. Our priority date is April 2023. When will our priority date become current?" So what I'm going to do is pull up the visa bulletin. I guess first blush answer, Lester, will be that um, it is really hard for anybody to predict the visa bulletin in a long-term basis. Why? Because not even the government knows where it's going to be next month. They calculate these things on a month-to-month basis. But with a priority date of April 2023, and considering you're asking me about it right now with the hopes that it'll soon be current, excuse me, I would presume that either that you are from one of the rest of the world countries, or perhaps Mexico and the Philippines, that have the same sort of dates. And right now, EB3 for those countries is in November of 2022. So I think my short-term answer is Lester, based upon what the visa bulletin's been saying at the end of it, I don't think you would expect to see any sort of positive movement on that before the end of the fiscal year, which continues to the end of September. Don't hold your breath on that one. Really? when it comes to the next visa bulletin, I think that would be of any interest to you would be October of 2024. That's when the government begins its new fiscal year, and there's a new crop of visas available. And when you see that visa bulletin, you will get an idea as to, what sort of well, there's new visas. You will see. Should hope you would see movement forward, and if you see movement forward, you can get an idea of maybe how far it could possibly go during the fiscal year. In this modern world, you are kind of asking the visa bulletin to move, 8 months, which doesn't really seem that much. But earlier in this presentation, I had said to myself, and I said to my audience, of course, it seems like we're looking into going back to a world prior to COVID where the visa bulletin moves slowly. And that's sort of the worst possible news I can say for people who, especially in the India and to a lesser extent, China backlog. But historically, pre COVID, the rest of the world categories were mostly current. So I guess I don't see it as impossible that those dates can come up during the next fiscal year. But, I think my general thought on that subject would be, you know, definitely don't count on anything until October, and let's see where October goes, and you really kind of get an idea as to what the possibilities might be. Um, so the next question I'm going to hit here is from Sai. Sai says, "Hi Brian, I have an EAD/AP card with pending I-45 priority date, August 2014, India EB2. I probably won't get my green card for 5 years based upon my current trend, and I hope not, Sai. But obviously, I try to be a realist. Part of the way I interpret my job as an immigration attorney is to not overset expectations. I feel bad if I give a prediction and reality doesn't. It's not a great way to make happy clients. I would rather have the government, overperform rather than underperform. So there's that. But the second half of your question here, in that case, wouldn't my EAD card hold the same advantages as my green card? Even if I suffer a job loss, can I remain in the country and maybe do self-employment? Is my understanding correct? So, a great question here, Sai, and let's unpack it. So, I'll start with the last question. I'll go answer your questions here directly, and maybe I'll expand more upon it. So EAD and having an advanced parole as well has a lot of the benefits of having a green card. EAD allows you to work like a green card does for whatever period of time, 5 years, for example, and advanced parole allows you to travel while your green card application is pending. So if you suffer a job loss, definitely self-employment's an option. Sam is definitely a major advocate of that, and well, I have to be as well. Bottom line is, self-employment is very clearly identified as being accepted by USCIS for the purposes of getting a green card, and that would involve, filing an I-45J saying I'm moving to my new employer, which is Sai Incorporated, and they're going to be my green card sponsor. I guess the big picture is you have to run that business like a business. You can't sort of do a poor job of it. What you really kind of have to do is plan it well. And what that might look like is, well, obviously, creating a business, proper business entity, creating a website, having somebody to run it, who's not yourself, perhaps, your spouse, because you have to be working in a same or similar occupation. Because let's say, your green card is for a software development role and you're supposed to be working in a same or similar occupation. Being CEO of your company is not really a same or similar occupation. But again, scenario pretty easily resolved. You have your spouse serve as the president and the president and CEO on their EAD that allows them to do anything, and you can offer yourself employment in that role of software developer, for example. I guess it's not impossible for you to be for you to be the CEO. Your full-time work has to be in a same or similar occupation. Arguably, I guess you could do that CEO stuff on the side when you have a green card. But just a sort of thought I had there. But bottom line is, yes, self-employment is an option. So if you don't have the option to do anything else, you can create self-employment. I have a lot of we have talked to a lot of people who are IT consultants, and if you can't find one project that can give you full-time employment, be it through your current H-1B employer or your current regular employer, it's very possible for you to put together piecework. Three gig jobs or 4 gig jobs can come together to full-time employment. Great. That's a business. It isn't everybody doing gig work. Isn't my work as an immigration attorney just putting together a bunch of clients, and as soon as I have enough of them to work full time, I have a full-time job. Very possible for you to do it. Very possible to do it through your own employer. It's something you should think about. Something you should talk to an attorney about. Something you should plan for if that's your plan. But definitely something to do. Gonna move on to the next one here from Prem US Vlogs. My priority date is November 28th, 2012, EB3 India. It is not current yet, but based on I-45 inventory, it will be current in the next fiscal year. Can I go ahead and do the medical examinations again? So, a great question. So, I will basically turn your question, Prem, into a public service announcement, all relating to medical exams for people who haven't heard it. And in the meantime, you heard me clicking on my keyboard. I've gone to the USCIS form website for I-693, and I'm going to read you as to what it says on there, the most recent alert on that website. Effective April 4th, 2024, any form I-693, that's the medical exam form, that was properly completed and signed by a civil surgeon on or after November 1st, 2023, does not expire and can be used indefinitely as evidence to show the applicant is not inadmissible on health-related grounds. And that's really what the medical exam is about, is whether you're inadmissible on health-related grounds. So what does that mean? If you have a medical exam that is signed by the civil surgeon, the doctor, on or after November 1st, 2023, from now on, from here on in, per this policy, that's good forever. So it is not a bad idea to go ahead and get yourself a new medical exam and send that to USCIS. So as soon as your party date becomes current and they pick up your case, they have a complete case they can approve without issuing you an RFE, which you would not like to receive. Some general thoughts about doing that. USCIS is not very good at taking unsolicited mail. So the hypothetical scenario I'm thinking about here is, Prem goes to the civil surgeon, the doctor, and gets a new medical exam, and then he sends it to USCIS, and they can lose it. I guess my humble advice on that one would be, go ahead, send in your medical exam now. They haven't said anything recently on the subject of, hey, don't send these to us, and send it in now, and keep another one for yourself. Get 2 copies, and just in case you get that RFE down the road from a dumb officer, you can have one, or maybe not a dumb officer, and that's not respectful. I do apologize. But maybe somebody if the medical exam doesn't get to your file, you'll have another one back up that's dated after November 1st, 2023. And I might add that generally speaking, we've had some pretty good success basically sending those medical exams early. I can think of a fellow who probably got his green card faster than he might have otherwise by basically, as soon as his priority date was current, contacting them saying, hey, my date's current. You've had my case since, October 2020. Here's my medical exams. Here's a recent supplement J. Please approve my case. And that's a scenario where I saw that happen. So a follow-up question from immigration here. I have an EAD/AP, but I'm maintaining my H-1B. Can I take up a board advisor role in this capacity in addition to my H-1B job role? Please let me know. So, that's maybe big picture and small picture. This one for you, immigration. So I'm gonna start with the big picture. Big picture is you have an EAD/AP, and if by chance that you were that board role were to be considered outside of your H-1B, and USCIS said, "Aha, we got you. This board role is employment. You're outside of your H-1B." Your response is, of course, well, who cares? I have an EAD. I'm allowed to do anything I want on that. It's infinite. I can work 10 different jobs. So that's the big picture. The micro question is that board advisor role is whether that, does it put you out of H-1B status? I guess is essentially the question you might be asking here. And my answer is those questions are difficult to answer in a venue like this. bottom line, I think the analysis of these are pretty, fact sensitive, and I would want to have a conversation with somebody about that. Uh, what does that board advisor do? What, are they compensating you anyway? That sort of thing to basically figure out whether something would be considered employment. Because, you know, um, I tend, I guess when I was shiny and new and I didn't know anything about immigration law, I guess if you would ask me, what's the definition of employment? It's got to be a black and white answer somewhere. It's not really that great an answer. You know, uh, Issues of employment could sometimes be a slippery slope. The common scenario I think of for that is the day trader. People on H-1B visas are allowed to own stocks, right? But what if suddenly you're spending so much time a day on day trading, analyzing stocks, and you're outperforming your H-1B work on day trading? I don't know. I think there raises a reasonable question as to whether that would be considered employment. Again, I don't know much about the board advisor role, but it sounds interesting. I think it's worth talking to somebody about. And obviously, again, if you have an EAD, AP, you're allowed to do whatever kind of work you want. As a fun note, advisory board roles are something that sort of checks the box in my brain for EB-1A visas. I'm going to Google again for the USCIS EB-1A criteria, right? And on the list of things is, let me see, evidence of your membership or associations in the field which demand outstanding achievement for their members. It may not be exactly what they're looking for in terms of EB1 membership in groups, but if somebody's reaching out to you saying, "Hey, you seem like a smart guy. We want you on our advisory board for XYZ," the sort of thing I might mention in an EB1A case, which is just sort of interesting. So I'm going to move on, and thanks for that question, immigration. I do appreciate it. To a question here from Santosh, who I also thank for his question. Santosh says, "Hi, Brian. If biometrics is done a month ago and priority date is still current under employment, in this case, do you think USCIS might issue a green card before the end of this month and issue a green card before end of this month instead of EAD and interview?" So I guess in this scenario, Santosh has a pending EAD. I would say this: the adjudication. First of all, Santosh, in your mind, as far as I know, they don't really sort of tie. I'll tell you about the interaction, I guess, between your pending EAD application and your green card application. Very little. If your green card's approved, if you get the very common thing we get is when somebody gets a green card approval notice, they'll also get kind of a scary notice in their mail relating to their EAD, which says, "Decision: we've denied your EAD." And they kind of call and go into panic, and it's say, "Well, they denied your EAD because you don't need it because you have a green card." So I don't think, generally speaking, and I don't think anybody has a really great way of knowing this for sure, that your EAD pending is going to impact your green card as well. But if you have a current priority date and a complete green card case, and I think it's possible for them to approve your green card at any time. I'll give you sort of an anecdotal thought about this. Just in the last couple of weeks, a gentleman who's had a pending green card, employment based for about a year, maybe a little bit over a year, said, "Brian, I'm frustrated with the government. My priority date's been current for a while, and they haven't approved my case." And I said, "Well, here's what we can do. We can go ahead and write a polite letter to USCIS saying, hey, my case is approved. My case is approvable. So please do it." And I said, "Happy to do it." And I just let him know, keep in mind, they could approve this case at any time, and maybe this letter won't do anything. Literally, as soon as he retained us to write that letter to USCIS, he got an approval for his green card. So maybe they knew that we were coming for them. But the point is, really, don't try to apply too much logic by the way they process your cases. But if your priority date's been current for a while and your case is complete, it doesn't hurt to basically rattle the cage at USCIS, be a bit of a squeaky wheel, send a letter. A polite letter. I mean, here's what I like about the concept of sending a letter to USCIS. If anybody out there has ever pulled a FOIA on themselves on their immigration file, they'll see that every case, whatever was sent by your lawyer or by you to the to USCIS on it, is in there, right? And for example, we've sent, polite letters about transfer underlying basis, for example, those appear in your file. I guess the point I'm making is that if you send something to USCIS, somebody has to pick up your file and add it to it. And I literally do mean pick up the file, because I've been to plenty of green card interviews, and USCIS officers, they will, even though they're trying better towards digitalization, they will come along with your file, your green card application, in a big green manila folder that they will pull out of a box. I literally had one once where the gentleman's entire file was the size of a banker's box. But the point I'm making in my long-winded kind of way is, if you go ahead and give them reason to touch your file, like, I don't know, put a letter in it with a letter that says, please, 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 my priority date's current, it might give them one excuse to pick up your file when they're putting that in there, and it might make somebody, maybe if you're lucky, pick that up and actually look at it and say, oh yeah, his date is current, I should make a decision here. So going to keep on moving on here. So I'm on H-1B with my employer, filing extension this week. My current H-1B expires in November 2024. If my extension is not yet approved, can I travel and return on my current visa or AP? So travel questions are very, very fact specific, and your name is Sihys, I guess, Sihys. And I would decline to answer that question directly here, but I'll talk to you about some general rules. When you have an advanced parole and a pending, if you have a valid advanced parole, let me make it simple. If you have a valid advanced parole, great, fantastic. You should be able to use that to leave and re-enter the United States at any time during its validity period. Great. Traveling with your pending, if you have a currently valid H-1B visa and H-1B approval notice right now, everybody knows the rules. A current visa stamp and a current approval should allow you to travel. And when the questions that I guess sort of might hurt my brain and might sort of take too long in this venue to explain are the impacts of how you return and on what status. For example, if you return on a visa, what I-94 takes precedence, the one that you get from customs when you enter the United States, or the one you get from your extension when it's approved? And what are the implications of you coming back on an advanced parole? And these are issues that are resolved. And again, it sounds like you have plenty of travel options because you have an advanced parole, but to give you definitive answers to that is, I think there's too many moving parts here with a little bit of information that I don't know. But it's, if you have an H-1B filing and you have filing coming up and you have a AP coming up, definitely talk to your employer's immigration counsel about your plans. Honestly, we always encourage our clients and their employees to talk to us about travel plans because, well, it's important. Travel can be a big thing and can have serious impacts there. So, I'm going to just sort of, as immigration here, I mentioned not knowing where he was. And one of the things I was thinking about is probably how long it would take to process a green card application in I-485. And for those who aren't aware, one of my greatest, tools in the immigration attorney's toolbox when it comes to speaking to people about their immigration issues is telling them what the USCIS processing times are. And if you look at the USCIS processing times, just do a Google search for it, you'll find their page. You type in I-485 and you tell them what kind of category, employment, family-based adjustment of status applications in San Francisco, California. They say the normal processing time, this is when they get to 80% of cases they say they're addressed are in 18 months. As I recall, I think immigration said his family-based green card case has been pending since August of 2023. So again, without some sort of, compelling explanation for them as to why they should care when your case has only been pending for 8 months or however long that is, 8 months, I think, maybe nine at this point. I wouldn't expect a decision on your family case for a while. It's the bottom line. Going to keep on going here with Raj's channel. I guess Raj has a channel. Hi, Brian. My priority date is March of 2023 for EB2 Rest of the World. Do you think I will become current in October? With the retrogression on the horizon for July Visa Bulletin, what is your opinion about this? So, um, I don't. So let's get everybody up to speed first, Raj. On the bottom of the Visa Bulletin, they say, and you're in EB2, visa. They say visa availability in the employment-based second preference category for the rest of the world, and all they say here's what they say: high demand in the employment second category will most likely necessitate retrogression of the worldwide final action date, including Mexico and the Philippines, and the next month to hold visa use within the maximum number allowed under fiscal year 2024 annual limit. So I well, first of all, let me give my disclaimer, Reg channel. Predicting the visa bullet is difficult. Don't print out what I say and pin it on the wall, and look to it to your solution of all your problems. But Sam and I have had the conversation, of my thought was, why didn't, if they're telling us that they're going to be running out of visa soon, essentially that's what the visa bulletin's saying. And if you're not aware, Raj, it's possible for them to make the visa bulletin you as an unavailable. We have no visas left, and they're not telling us they're intending to do that. They're just essentially trying to roll back the dates so far that they can't accept new cases that would, bar them from they're trying to get the visa bulletin to a point where they know they're going to have visas available for all the dates that they're accepting. I guess I wouldn't really take the retrogression that's coming right now as determinative as to what happens in October of 2024. Separate them. I think the retrogression on the visa bulletin is done. It is done because they're running out of visas. But just because it's moving backwards, it doesn't necessarily mean it does say it, it doesn't necessarily. They're not saying demand is higher than they expect, or they're hitting some sort of massive wall of applications. They're just saying we need. Maybe it's saying that their last prediction was not perfect. Uh, Take the visa bulletins as they come, because even the Department of State does not know what the next visa bulletin is going to say. They try to predict them. They try to be honest about them, and they're trying to be good by posting, on the end of it, what they think is going to happen. But again, even they themselves have said, don't count on anything you see here to necessarily reign true in the future. And I guess I'm going to say, look for October and see, and then leave it there, I guess. So, um, and Empire sort of asked a related question. We're expecting retrogression for EB3 rest of the world. Do you think it will be weeks or months? And sort of a follow up here. Also, for October, where do you see the filing dates going? Will it retrogress similar to this fiscal year? So, I don't dare predict a October visa bulletin because they're crazy. That's when new visas available. One hopes for movement forward, of course. Um, for me, for the rest of the world, I guess I'm going to try to take a step back from what the visa bulletin says and sort of disconnect myself from that. And I guess I sort of try to offer people gentle encouragement this way, different ways of thinking about things. Um, just because the visa, I know the visa bulletin retrogressing is sort of a punch in the gut, right? And you don't want to see it move back when all you wanted to do for your own personal benefit is to see it move forward to your date. I guess what I would say is that um, what the visa bulletin says is obviously reflective of visa availability, but as long as the government is giving away all the visas that are available, I try not to sort of analyze the visa bulletin too much. When people should be upset is when the government doesn't give away all employment-based visas, or which has happened in the last couple of years, and that should be obviously very upsetting. But a retrogression, more or less, for most people, the date that you get they're supposed to give away green cards in the order of which people's priority dates are. Thereby, in theory, the date that you get your green card is, should be kind of logically set in stone. It's just a date that we don't know yet. I guess what I say is I try to not worry too much about where the visa bulletin's going, because you cannot control it. It is entirely in the government's control, and whether or not the visa bulletin says 1 month or another, as long as until your date's current, you're there's not a visa available. So I'm gonna for October, I'm gonna maintain cautious optimism that it's gonna creep forward a little bit, because that's when new visa availability is, and that's when we see movement on visa bulletins, is the bottom line. I guess I just apologize if I got too much in my head there. The bottom line is, I get to encourage people to not obsess too much over the visa bulletin, because you cannot control it. The visas, as long as they're using all the visas, I mean, obviously be disappointed because you want your green card now, but um, the bottom line is how it should work is you get your green card when everybody in front of you gets their green card, and they're as long as they keep on giving, you're getting, no matter what, you're always getting closer every year when more visas become available, and that's sort of how I have to choose to think about these things to not get too stressed about it. So from another sort of follow up here from Sahis, and I apologize if I'm mispronouncing your handle. So USCIS has a goal of 2 months for processing of non-premium processing renewals. Of non-premium processing of renewal H-1Bs, but how soon are they actually processing them? And I'm not sure where you're seeing the goal number from, but I haven't checked those numbers for a while. But since I'm on the USCIS processing time website, I guess we can see what USCIS is saying. Maybe that's where you're getting the number there. So again, go to the USCIS processing site. Let's say extension of stay, H-1B extension of stay in the United States, which is what most people cases are. And I'm going to check the service centers. California Service Center. They say that they are getting to 80% of cases in 3 months at California. So a lot of cases are, 20% of cases are going longer than that. So that gives you an idea as to whether they're hitting 2 months there. Nebraska Service Center, 80% of cases in 4 months. Texas Service Center, 80% of cases in 6.5 months. Vermont Service Center, 80% of cases in about 7 months. So I wouldn't bother boring everybody by going through our personal office mail here to see what we're seeing. But I guess what USCIS is saying is that is a goal, considering that, several of these officers are saying, all these officers are saying more than 2 months. It is definitely just a goal. So if you have a need, obviously, keep it premium processing, which unfortunately now costs more, is really kind of what it's all about. So from Chandrakant, hi Brian. With around 3,000 immigrant visas per year in EB2, EB3, based upon the I-45 inventory data released a couple weeks back, how many years does it take to clear all that backlog? I will tell you a bit of a Brian story. When I went to undergraduate school initially, Chandrakant, I went pursuing a degree in mathematics, and I quickly determined it wasn't for me. And I chose to got an undergraduate degree in English, and then ended up becoming an attorney. Went to law school, become an attorney, obviously. I think that answer is something that is practically incalculable, because there's ultimately factors that are beyond our control. If you had told me, just think of the COVID scenario. There are 1,001 X factors, ones we haven't even considered yet, that could put those could speed things up. No doubt, COVID was an absolute tragedy. People waiting on family immigration were absolutely kneecapped in that process, because the consulate wouldn't issue family visas because, well, they just didn't. But fundamentally, it's been really good for employment immigration, made more visas available, more people got green cards. There's also a tragedy in that the government wasted those green cards. They didn't issue them in certain fiscal years, and they burnt tons of visas. I guess the bottom line is, one of the things they said, USCIS, for those who aren't aware, has this great website. It's called Employment-Based Adjustment of Status FAQs. do a Google search for that. It's literally a page on uscis.gov, employment-based adjustment of status FAQs. They last updated on May 20th, 2024, which I don't think I've seen yet. I'm gonna have to see what that is. But one of the things they said in this FAQ, which are really interesting, I would encourage everybody to read them. In fact, I'm gonna do you guys a solid of putting a link to it in the chat right here. Go ahead and take a click there and read through it. But one of the things they said, I think it was back in September of 2022, or maybe September 2023, they said we have I-485 inventory to cover years of visa bulletin movement. So years. I can't say how many. The answer is, certainly, many of them. Um, and that's that. And the last thing I do is I'm going to give myself a round of applause for staying a little bit longer and to try to get to everybody's questions. Um, just for immigration here, mentioning his board advisor. Uh, again, that's the sort of question, the capacity of your board advisory sort of thing. Um, it's the sort of thing where I would usually have a conversation with somebody about something like that. But really, to answer your sort of the full big picture answer to your question, immigration is if you have an EAD, the worst case scenario. If the decision is made some time that's not employment, go ahead and do it, right? And you're on H-1B status. If the government comes back later and says, "Whoa, whoa, 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 let's work," you're not on H-1B status. The answer is a resounding who cares? If you think I violated my H-1B status, too bad. I have an EAD. I'm good. So I will sincerely thank everybody for tuning in this evening and listening to me monologue about immigration issues. I have proven to the world that I can have an hour-long conversation with myself, and somewhere out there, I have several friends and my wife laughing in the audience, already knowing that it's definitely the case. So I will see you guys back here 1 week from today, Monday, 6 p.m. Eastern Time. And always appreciate your feedback. Always appreciate your tuning in. I will wish everybody a fantastic week and a good evening as well.